Good afternoon, everyone. I'm Alyssa Gresh, the Executive Director of the American Association of Jewish Lawyers and Jurists. Thank you for joining us today. For those of you who don't know, AJLJ is dedicated to strengthening the rule of law, protecting human rights, and supporting a secure and democratic Israel. A central part of that mission is bringing clarity and legal expertise to issues that are often politicized or misunderstood. Today, we're focusing on Area E1. It's a small section of land between Jerusalem and, I'm hoping I pronounced this correctly, Ma'ale Adumim, that has triggered global controversy for decades. Israel's recent approval of development there has sparked renewed international pressure and sharp debate about security needs, settlement policy, and the future of a Palestinian state. We're privileged to have Joel Margolis guiding us today. Joel serves as AJLJ's legal commentator. He regularly publishes analysis on Israel's rights under international law and the legal dimensions of anti-Semitism in the United States. His 2021 book, The Israeli-Palestinian Legal War, explores the major legal claims and counterclaims that have shaped this conflict. Joel also practiced telecommunications law in both government and private practice, giving him a unique ability to translate complex legal issues clearly and fairly. And before turning it over to Joel, I'm just going to make a few announcements. I'll make them after the program as well. We have some exciting upcoming programs. In Washington, D.C. on November 4th with Professor Gerald Steinberg, Lawfare and Libel, Strategies to Reverse the Weaponization of Human Rights and International Law. We have the Pursuit of Justice Awards in D.C., and that's going to be at the Women's Democratic National Club. Those of you who have asked about the location, I did not put that in the invitation for, some organizations connected to Jewish and Israel-related events do that. And on November 23rd, the information will be going out on this shortly. There'll be a film screening in New York City at Kehilath Jeshurun it's called The Honorable Mr. Morgenthau. So please join us. And if you're not a member yet of the AJLJ, also please join us. And on that note, I'm going to hand it over to Joel. And also, if you have questions, you can feel free to write them in the chat, and we'll get to those after Joel's discussion. Thanks.
Okay, thank you, Alyssa. Good afternoon, everyone. I hope you can all see the introduction slide. This slide summarizes the three questions I'd like to address today about Israel's plan to build settlements in a zone called Area E1. First, what law permits Israel to build settlements anywhere in that region of the globe? Second, do the settlements in that region violate the Geneva Convention rules governing occupation law? And finally, do any particular restrictions apply to Area E1 itself? This will be a high-level discussion. It will take about 15 minutes, and then we'll have a Q&A. So, on August 20th, Israel announced a plan to build 3,700 housing units in a corner of Judea and Samaria, otherwise known as the West Bank. The development project targeted a district called Area East 1, or E1. If you look at the photo on this slide, you'll see what looks like a barren landscape with an Israeli settlement in the foreground. That's the settlement of Ma'ale Adumim. The city in the distance is Jerusalem. And that dusty middle ground, which is about 4.6 square miles, that's the undeveloped western piece of Ma'ale Adumim called Area E1. Because Area E1 sits just east of Jerusalem, it's a major flashpoint in the Israeli-Palestinian conflict. Now look at the map of Area E1. Notice the E1 zone not only touches Jerusalem, but stands between two major Palestinian population centers. There's Ramallah in the north and Bethlehem in the south. Also notice the winding yellow road that's partially under construction. That will give Palestinians a new and faster travel route between Ramallah and Bethlehem after E1 is built out. Now let's examine the legal issues. May Israel build settlements in Judea and Samaria? The answer is yes. Both Israelis and Palestinians may lawfully build settlements there, provided they stay within the respective geographic limits they negotiated in the Israeli-Palestinian Oslo Accords of the 1990s. It's important to see how that arrangement evolved, so let's briefly recount the 6 related landmarks of legal history that made it happen. The legal significance of these landmarks is completely ignored by the Palestinians. So, landmark 1, the 1920 San Remo Treaty contained a grant of authority for the Jewish people to establish the state that became Israel. And the scope of that authorized territory included Judea and Samaria. 2 years later, the 1922 British Mandate for Palestine outlined the process to build the Jewish state. In particular, Article 6 of the Palestine Mandate required dense settlement by Jews on the land. Now, don't be put off by the word settlement. It's not a legal term. A settlement could be a home, office building, an orchard, an industrial park. Unfortunately, certain progressive scholars have used the term settlement to stigmatize Israel as a settler colonial state, even though Israel was never the colony of any other state. That brings us to landmark 3. In the Arab-Israeli War, Jordan illegally invaded Israel, occupied Judea and Samaria, and renamed it the West Bank. But that illegal aggression did nothing to diminish Israel's sovereign rights under San Remo or the Palestine Mandate. In the 1967 Six-Day War, Israel overthrew the Jordanian occupation and finally took rightful possession of Judea and Samaria. Landmark 5. Jordan renounced its claim to Judea and Samaria, and the whole territorial dispute between Israel and Jordan was formally resolved when they signed their peace treaty in 1994. That brings us to the last landmark, the Oslo Accords. They gave each party, among other things, interim control over certain portions of Judea and Samaria. The parties agreed to resolve the issue of settlements in a future negotiation. Meanwhile, each party remained free to build settlements within its own area of interim control. So, based on the above 6 legal landmarks, Israel may validly build settlements within its Oslo-assigned area of interim control. Depending on the outcome of the Oslo negotiations, if and when they're ever concluded, either party may ultimately agree to dismantle some of its settlements or relocate them. So none of the current property rights is etched in stone. With that background in mind, do Israeli settlements violate occupation law? Well, there's nothing illegal per se about an occupation, and there's nothing illegal per se about a settlement in occupied territory. And yet, the Palestinians, along with most of the world, allege that Israel has violated occupation law. How do they make that case? They do it with 2 leaps of logic, which ignore all 6 of the above legal landmarks. The first leap of logic is simple enough. They say Israel occupies Judea and Samaria. However, the whole purpose of occupation law is to identify when a state's armed forces have captured some foreign land, not when a state liberates its own land. Even if Israel had captured foreign land, it was not foreign land owned by the Palestinians. The Palestinians never had a state that could be occupied. So the Palestinians cannot stand in the occupation law role of a, quote, ousted sovereign for purposes of any legal remedies. And even if the Palestinians were somehow deemed to be an ousted sovereign, occupation law, by definition, would still not apply to any territory that remains under their, quote, effective control. That's important because over 90% of the Palestinians in Judea and Samaria live in territories under their own effective control, thanks to the Oslo Accords. So there is no occupation of Judea and Samaria. Now for the second leap of logic. If you believe an occupation exists, the Palestinians proceed to claim that Israel violates the occupation law found in Fourth Geneva Convention, Article 49. I'll simply call it Article 49. Article 49 prohibits an occupying power from A, deporting or transferring its own citizens into the occupied zone, or B, deporting or transferring the occupied population outside the occupied zone. Palestinians say Israel violates Article 49 because Israeli citizens keep relocating to Judea and Samaria. Here's the problem with their Article 49 claim. The express intent of Article 49, as stated by the authors of the Geneva Convention, is to prevent forcible transfers of populations in acts of ethnic cleansing, not the kind of voluntary relocations pursued by Israeli citizens. Israeli families living in Judea and Samaria are hardly the victims of ethnic cleansing. So there is no violation of occupation law, even if you believe there is an occupation. Now let's confront the specific complaints about settlement building in Area E1. E1 is within Israel's realm of interim control under the Oslo Accords, so building settlements there is legal. But before we examine the objections to the build-out of E1, why must Israel build in that particular spot? The reason is because Israel is struggling with a dire housing shortage. In fact, Israeli residents of Jerusalem are actually leaving the city due to the prohibitive cost of housing. Everyone recognized as early as the 1990s that more housing should be built in Area E1, but the initiative was repeatedly delayed due to international pressure to prevent Israel from expanding into Area E1. Israel also considers Area E1 vital to its right of self-defense. Because the E1 build-out would connect Jerusalem to Ma'ale Adumim, it would make both communities more defensible from Palestinian terrorist attacks. Even those who consider Israel an occupying power must admit that an occupying power is legally entitled to appropriate and develop property as needed to meet its military goals. That's why I'm pointing out the military need of developing E1. As we know, national security is a major sore spot for Israel since the October 7th Hamas invasion, and those fears were magnified when certain European nations recently declared their recognition of a Palestinian state. So, what are the arguments against developing Area E1? Opponents raise three concerns. The first concern is with north-south continuity in Judea and Samaria. Palestinians complain that any Israeli development of Area E1 would bisect Judea and Samaria widthwise and thereby create facts on the ground, as they say, that would preclude the emergence of a contiguous Palestinian state. In fact, building out E1 would not fully cut Judea and Samaria in half. There would still be room for Palestinian continuity. Anyway, let's remember, the Palestinians already demand a state that incorporates a non-contiguous sector called Gaza. And beyond that, many states in the world own non-contiguous lands. There's nothing new about that, and certainly nothing illegal. If anything, I think it's ironic that Palestinians complain about territorial continuity. For decades, they themselves have made attempts to plant prefab homes in Area E1 in a scheme to block Israeli continuity between Jerusalem and Ma'ale Adumim. So Palestinians don't exactly have clean hands to make the continuity argument. Now let's focus more closely on that east-west continuity between Jerusalem and Ma'ale Adumim. Palestinians argue that because Area E1 would connect Jerusalem to Ma'ale Adumim, it would preclude continuity between their desired capital in East Jerusalem and the rest of their desired state in Judea and Samaria. However, Palestinians don't advance a single legal reason why any of Jerusalem should be their capital. nor is there any historic support for the claim. After all, Jerusalem was never the capital of any Arab or Muslim state. The Palestinian seat of government is Ramallah. In any event, Israel long ago exercised its sovereign right to name Jerusalem as its capital city. As a result, the Palestinian plan for East Jerusalem would violate Israeli sovereignty. And speaking of history, it made sense to declare Jerusalem the capital of the modern state of Israel because that was the capital of the ancient kingdom of Israel as far back as 1000 BCE. The third Palestinian complaint about Area E1 is based on good old Article 49. Remember, Article 49 says an occupying power cannot deport or transfer an occupied population outside the occupied zone. With that in mind, Palestinians complain that Israel is evicting the Bedouin Arabs living in Area E1 to make way for the planned development, and that allegedly violates Article 49. Well, it is true that an estimated 3,500 Bedouin Arabs, mostly shepherds, live in Area E1, and they are being evicted. They live in makeshift villages off the grid with no electric service, no water service. The reason is because those villages were never authorized by Israel's civil administration. They were built illegally, so they are plainly subject to eviction. Evicting someone from an illegally built home to make way for illegal property development, that may not be a pleasant task, but it is not a forcible deportation or transfer, and it's certainly not an act of ethnic cleansing. Besides, no Bedouins would be deported or transferred outside any occupied zone because they would remain inside Judea and Samaria, which the Palestinians themselves consider part of the occupied zone. So the Bedouin evictions from Area E1 do not violate Article 49 of occupation law, even if you believe an occupation exists. So where does this leave us? Hopefully this legal review shed light on the development of Area E1. The development is lawful, and it would not violate any Palestinian rights. That said, the implications of the E1 build-out are serious. It would solidify Israel's hold on a key crossroads in Judea and Samaria, which both adversaries consider strategically vital. In addition, it would potentially shrink a future Palestinian state by about 4.6 square miles. The entirety of Judea and Samaria is over 2,000 square miles. And finally, the build-out would frustrate Palestinian efforts to make East Jerusalem the capital of their desired state. The capital would probably have to stay where it is, in Ramallah. So that's my presentation. Thanks for listening.
Great. Thank you, Joel. If you have, I'll start with one question actually from that I have myself. Hold on. Oh, somebody did ask if I could distribute your slides. See.
Sure. They've been declassified, so yes.
Hold on. Chat a question. So I guess the first. So recently the Knesset passed a first reading, I believe, of the bill to annex, in quotes, Judea and Samaria. And there's a separate bill to annex just the settlement of Ma'ale Adumim. So if Israel does annex that, it would be applying its law and administration. So what would then happen to Area E1?
Okay, I think I can tackle that. Last week, Israel's Knesset actually pursued two pieces of legislation on a parallel track. One would apply Israel's sovereignty to just Ma'ale Adumim. The other would apply Israel's sovereignty to all of Judea and Samaria. So the question becomes, let's say a bill passes to apply sovereignty to just Ma'ale Adumim. Would that include Area E1, which is so bitterly fought over by Israelis and Palestinians? And the answer is yes, because E1 has always been part of Ma'ale Adumim. So by definition, if that bill passes, then Israel could not only build out Area E1, a project which has already started, but it would be much, much more difficult for the Palestinians to raise any legal objection.
Okay, so somebody just asked, so Richard Horowitz, hi Richard, asked them what are the counter arguments to the ICJ ruling that Israel's occupation of the West Bank is illegal.
Right. The ICJ made a ruling in 2024, which seemed to declare that the occupation was illegal. What they really said was the way Israel is using, or they would say misusing, the occupation is illegal. They said Israel has prolonged this occupation for way too long. It's supposed to be a temporary state of affairs just until a war ends. And Israel, by developing all these settlements in Judea and Samaria, has affected what they call a de facto annexation of the land. If you look at occupation law as it's written, before interpretations that were very deliberately tailored to antagonize Israel, there's nothing illegal about an occupation. And the way I think of it is, if two people live side by side in an apartment house, one is the owner of, let's say, that unit as a condominium, and let's say the person next door is just a renter. Does that mean that either occupant of that apartment building has violated some law? No, of course not. It just means two people are living in two defined spaces of land under different legal titles. It's just a descriptive status. So occupying something does not mean you violated anything. And in the case of Israel, it doesn't apply because, as I tried to explain at the outset of my talk, the San Remo resolution, otherwise known as the San Remo Treaty, earmarked all of Israel proper and Gaza, all of Jerusalem, and all of Judea and Samaria for the state that became Israel. That gave Israel a sovereign right to all of Judea and Samaria. And to this day, no other party has as strong a legal claim to that land. So it makes no more sense to say Israel has occupied Judea and Samaria, which it already holds a legal claim to, than it does to say the United States occupies Kansas. It's just a non sequitur.
Thank you. That's really interesting. Does anybody have any other questions? If you do, hold on. Okay. So who has legal ownership of the land in this territory?
Oh, okay. I assume you're referring to E1. E1 has already been designated state land. And let me back up in time a little bit. Under the Ottoman Empire, much of Judea and Samaria was owned by the Caliphate. It didn't come under any private property ownership. Then, when the British became the authorized mandatory or administrator of that area, the British decided to preserve the Ottoman classification of state land. Then, when Israel declared independence in 1948, Israel confronted the same issue. How much of this land is public? How much is private? And they went through an exhaustive study with a team of researchers. And it was very difficult because a lot of people in Judea and Samaria who claimed to be private property holders there, they couldn't show any evidence, no deed, no title, no purchase agreement, no tax records, nothing. So what the team did was they said, in all those cases where people can show at least some scrap of evidence of private ownership, we'll call that plot of land privately owned. And all the rest will just dump into that other category of state land. That's where E1 is. E1 to this day is state land.
Whoops. Alan Fischler notes that it's a bit of a political question, but do you have any comment personally on the timing of the Knesset action?
Prime Minister Benjamin Netanyahu has already said, we're not going to apply sovereignty to all of Judea and Samaria. He may want to. In fact, based on his political track record, that's probably what you might expect him to do. But he's trying to walk a tightrope right now and remain in the good graces of President Trump and the United States, which has already stated very flatly, they're not ready for Israel to change the legal status of Judea and Samaria. So Netanyahu has already come out publicly and said it won't happen. So that convinces me it won't happen. As for that second bill to apply sovereignty to just Ma'ale Adumim, boy, it may be slightly more realistic, but knowing what we know about Benjamin Netanyahu and how closely he has tried to stay on the same page as the US, I think he would have a very long, hard talk with the most senior levels of the US administration before pulling an act like that.
So if it's owned by the state of Israel, can the state lease it for hotels?
Well, there are different ways that land can be used. And let's be conservative. Let's say all of Judea and Samaria is occupied, because otherwise we wouldn't need to ask that question. Israel could build in E1 for the same reason that US could build in Kansas. So I'm going to assume, based on the question, that all of Judea and Samaria is occupied. Well, an occupying power cannot confiscate land, in other words, take it away from a private title holder without paying just compensation. And there has to be a military purpose. There was a landmark case in Israel in 1979 called Elon Morin, where the Supreme Court struck down an IDF decision to take land because they couldn't come up with a military purpose. They said, we'll compensate them, but the court said, no, compensation is not enough. So confiscation is the most difficult thing to do if you're an occupying power. Expropriation, a little bit easier. If you have a military purpose, you can expropriate land. That doesn't change the title, but you still have to show a military purpose. And then finally, there's the most mild category of all, and that's appropriation. If you believe there's some public interest or public benefit to the residents of the occupied area from building some infrastructure or buildings, maybe hotels, then yes, you can appropriate that land. But again, it doesn't change the title. And that's why Israelis living in the West Bank under state land, they all live as renters. They're not private property owners. They don't hold equity. They're just renters. So theoretically, if Israel and the Palestinians were to conclude the final status negotiation of the Oslo Accords, Israel could lawfully pull all the civilians off of all those renters, off of all the land in Judea and Samaria where they are now living for purposes of striking some kind of a mutual international border agreement with the Palestinians.
If Israel does annex Judea and Samaria, here, Harry asked kind of a follow-up question, but he said, but I thought the land was public land, which means should mean it's owned by Israel, or?
When Israel first acquired possession of Judea and Samaria, that was in the 1967 war. Israel had a very difficult moment deciding what is our status there, because they did not forget about San Remo. They did not forget about the British Mandate for Palestine. They knew Israel held sovereign rights to that land. But they also knew it was a very unusual situation, not contemplated by traditional law.
Hey, did you stay up?
And
I did.
I think someone has just joined our conversation.
Sorry, I got it. Yeah.
Okay, great. So Israel's Supreme Court realized that these occupation laws were never incorporated into Israel's domestic laws. So the Supreme Court had no jurisdiction to decide whether Judea and Samaria was occupied or not. It was beyond their jurisdiction. So to this day, Israel has never legally decided, and never wanted to, frankly, to decide that Judea and Samaria was occupied. And that's why they don't use the term annex when they talk about merging any of that territory into Israel proper, because you only annex territory if it's foreign to you. But Judea and Samaria is not foreign to Israel. So Israel says we would apply sovereignty to Judea and Samaria, similar to what they did with East Jerusalem to reunify that city. So the designation of state land, it really doesn't give Israel any more rights than they already have under San Remo, British Mandate for Palestine, and the Oslo Accords. It's like a placeholder. So Israel could apply sovereignty to the state land, and it would not have to compensate any Palestinian owners, because no Palestinians have been able to demonstrate ownership of any state land. But Israel is trying to show restraint. Israel forbears from applying sovereignty to any of Judea and Samaria, including the state land, because it still hopes, some may believe naively, but they still hope that one day they can negotiate in a bilateral negotiation, secure and recognized boundaries along with the Palestinian state. And who knows, maybe that day will still come.
Right. So do you think these two questions kind of go hand in hand? So if Israel annexes Judea and Samaria, what happens to the Jewish state and the rights of residents who would become Israeli citizens? And wouldn't that mean that those citizens would have the right to vote?
Oh, okay. Well, I assume you're talking about two different groups of citizens in Judea and Samaria. First, let's take the easy group, Israelis living in Judea and Samaria. They already have all the rights of Israeli citizenship. And it had to be that way, as the Palestinians recognized during the negotiation of the Oslo Accords. So you wouldn't have disparities of rights between Israelis living in Judea and Samaria and Israelis living in Tel Aviv or Haifa. So there'd be no change whatsoever in the legal rights of the Israeli citizens living in Judea and Samaria. The more difficult question is, what happens to the rights of the Palestinians living in Judea and Samaria? Right now, they are stateless. And in modern times, that's a very, very difficult situation to be in. Imagine not having a passport that declares your valid state and trying to travel around the world. So I believe, as I think most other people do, that everyone should have a state somewhere. But the question becomes, what if Israel applies sovereignty to all of Judea and Samaria, including the 3 million estimated Palestinians living there? Does that mean the Palestinians would become Israeli citizens? No. It means Israel would have sovereignty over the territory, but it's a separate legal issue whether Israel would grant citizenship to the non-citizens of Judea and Samaria. And when it comes to citizenship or the naturalization process, every state has the sovereign right to decide who may or may not become a citizen. Israel may decide to let all Palestinians in Judea and Samaria apply for Israeli citizenship and then decide, based on whether they meet the qualifications, which ones to grant citizenship to and which to say no to. And the closest parallel I can think of in the US is people who live in the US as non-citizens. You could be an H-1B worker. You could be a green card holder. And you do have certain rights by living in the United States. That's under US law. But the mere fact that you live here does not give you the right to US citizenship.
Okay, so I think it looks like there are no other questions for now. Anything that you want to add, Joel, or close on?
Yeah, I would just like to note that Israel at this point is acting out of fear, I think, as opposed to aggression. The E1 plan was put on hold for many decades, as I said, since the early 1990s. Why did it come to light now? I think that's at least in part because of Hamas's invasion. Israel reacted with all the horror you would expect. And then they had to take a second look in the bigger picture of where do they stand in relation to the Palestinians. And they had to take a third look when they saw these European countries who were considered allies of Israel, all legally turning against Israel by recognizing a state of Palestine. So I think if it weren't for Hamas's invasion, I don't think we would see Israel trying to develop E1 today. But the invasion happened, and I think E1 is a natural response.
Thank you. And I did put in a link to your book, Joel, but if you could say again what the name of your book is, so for anybody who
Yes.
wants to order it, they can do so.
Yes, my book is called The Israeli-Palestinian
Sorry, Joel,
League. Yes,
did
can
you
you hear
hear
me?
me?
Yeah, I'll try that again.
Uh-oh.
The book is called The Israeli-Palestinian Legal War. I published it in 2021, and you can find it on Amazon.com.
1 second. Oh. All right. Thank you so much, Joel. Sorry, I think my connection got a little choppy. Oh, that's great. Thank you, James. James Cohen just purchased a copy. Wow.
That's great. Thank you, James.
Wonderful. Thanks. Wonderful. So thank you again, Joel. This was really very educational, I think, for many of us. And we look forward to your next article. And I'll keep everyone posted on that. And again, I hope you all will join the AJLJ and come to our Pursuit of Justice Awards in December or our November 4th Washington, D.C. event. And if you're in New York, please come to our film screening on November 23rd. And thank you to everyone, and enjoy the rest of your week. And bye. Thanks, Joel. Bye, everybody. Thanks again.